Hello and welcome to the ICT Pulse podcast. I'm Michelle Marius, your host and the editor and publisher of ICT Pulse, the online platform where we discuss ICT issues from a Caribbean perspective. In this episode, we'll be revisiting privacy. Over the last few years and with the European General Data Protection Regulations, GDPR, in force, more Caribbean countries have been introducing data protection and privacy legislation. However, how is that ecosystem evolving and what impact, if any, is COVID-19 having on how we view privacy? These are some of the questions we'd like to address. Back with us once again, and we're thrilled to have her, is Grace Lindo, an attorney at law and a partner at Carter Lindo, a recently established legal partnership based in Jamaica. Grace's specialties include corporate and commercial law, intellectual property, and technology, and she's a certified information privacy professional. Grace, thanks for joining us and welcome back.
Hi, Michelle. Thank you for having me, and it's a pleasure to be back. It feels as if I just, stepped out of your studio, so I want to have a better term. Just the other day, time is really running, especially in 2020.
Absolutely. And the last time we had a conversation on privacy and data protection was actually 2018, so nearly 2 years ago now.
Wow.
And of course, life is so different from what it was then. And I just wanted to know, just to start us off, since 2018, a lot has happened. For example, Barbados and Jamaica did not have data protection legislation in place, but they have since promulgated the laws. So can you just give us an update on some of the key developments that have been occurring in the last 2 years?
Okay, right. So since 2018, we have seen quite a few, as you said, Caribbean countries move to have the laws put in place, data protection laws put in place. For us in here in Jamaica, our law has been passed by both houses. We're just waiting on the entry into law by the signature of the law by the Governor General. And of course, we're waiting on the regulations as well to accompany the law. But yes, here in the Caribbean, you've seen a lot of activity around data protection. And we're seeing more awareness. We're seeing people becoming data protection officers, and you're seeing posts being advertised for privacy officers too. So it certainly has kicked up quite a storm since 2018.
Wonderful. Do you want to just talk about anything else further afield?
Right. So the European Union, I think, really pushed many persons or many countries in the world to get their laws in order. I think when you look on, for instance, California now has a form of data privacy law, which is waiting on, I believe, something similar to regulations to come into force. But they now have for their state a consumer-specific data protection law. And when you think of the United States, you would never think that something such as that would be put in place, But yes, several jurisdictions have been taking the cue about data privacy, about e-commerce and about rising e-commerce, and seeing the need for data security and data protection.
Okay, fantastic. And since you're based in Jamaica, and you've mentioned the Data Protection Act, when it was going through the legislative process in Parliament, it was widely debated, and there were some contentious issues. Now that it has been passed, how were some of those issues resolved?
So there are several contentious issues because, it's a pretty large piece of legislation, but I'm going to highlight just one or two of them. One of the foremost issues we had here was the need for, blanket registration, and secondly, the need for a compliance officer by everybody who is registered, whether you are a small entity or a large entity. And there is somewhat of a compromise, which, now allows companies that do not deal with large data sets to be precluded from having to appoint a data protection officer, a compliance officer, that is. And so you can see where the government did give some consideration rather, to the cries of the small and medium entrepreneurs who felt that this was just over-regulation. So while that is being said, though, you can see that the Jamaican government took into consideration the risks involved in the processing of certain types of data. We do see consideration for opting in to, for instance, direct marketing. That was a provision which the Jamaican Parliament took from, I believe, South Africa. And so there were a few changes which were meant to be, are meant to be pro-consumer. And time will tell as to how those provisions will be implemented. But there was a move to listen to the stakeholders, certainly in Jamaica.
And you had mentioned two issues. You discussed the compliance officer situation.
Right. So the data protection regime requires the appointment of a compliance officer called a data protection officer. And this individual has the task of being almost a whistleblower. And for us in the Caribbean, and quite frankly for us in Jamaica, when you hear of whistleblower legislation or anything that involves whistleblowing, it does raise eyebrows because of the context that we're in. And we're not going to pretty that one up any much, because we do know that Jamaica comes with its own sets of problems. And really anywhere in the world, whistleblowing is not easy to do. So there is a provision for you to have a compliance officer who should be very independent and should be able to tell the company when they're going down the wrong road in respect of the use of data, but also should be able to report to the regulator in respect of any wrongdoings, if there is any processing of data which has a debilitating effect on the data subjects, which are more than likely the consumers who are using or who are provided the data rather.
Understood. Yeah, I guess that is a fair compromise, because clearly we can't have whistleblower pieces of legislation and especially within the context of, I guess, the Jamaican society, for example. And it's better probably that one has a more independent posture with the data compliance officers.
And that can be achieved. I believe that this will see the spurning of persons who can provide the services of data protection officers. The data protection officer does not have to be an in-house person. It can be external to the company, to the business. And so, like in Europe, you will see popping up data protection services, data protection officer services, rather, people who will start to provide that service as independent contractors to companies here in the Caribbean.
Yes, that's a wonderful opportunity, because I think, and especially probably when someone is an employee, there may be unspoken rules about the loyalties that need to be maintained. And perhaps if one probably had it where there may be a little bit more of an arm's length relationship, it probably will work well for all parties' mutual benefit.
Correct. Agreed. Yeah.
Okay. Now, probably let's just pivot a little bit to COVID-19. And I think, from what I've begun to understand and begun to read, a number of privacy concerns have begun to emerge. From your vantage point, what have been some of the issues?
COVID-19 has brought to the fore cybersecurity issues and the protection of data in that context, because we now have more people working from home, and so the security of our data sets and where they're held now comes to the fore. So that's one thing. But COVID-19 has also led to various methods which different governments have put in place to trace persons who either have the disease or have come into contact with persons who have had the disease, called contact tracing for us here in the Caribbean, and largely done for us in Jamaica at the very least manually. I know persons get calls as to where they have been and whether they have been in contact with somebody who has COVID-19. But in other jurisdictions, in other developed countries primarily, they have been using technology quite a bit. They have applications that alert persons now as to whether they have come in contact with somebody that has COVID-19, or whether they're in a particular area, which puts them at risk. Even here too in Jamaica, persons who are coming home to be quarantined had to download an application and log their geographic location each day. And I believe too the location indicators in respect of the application were also turned on, and that would have signaled back to the ministry, the particular ministry, where they were at any particular time. As to the effectiveness of those mechanisms, that's another argument for another day. But certainly that led to data protection and data privacy concerns, and whether there was sufficient consent, but also whether you needed consent. My own view is that, data protection laws do have exemptions which allow for public health and legitimate processing bases for the use of the data of, personal information of individuals. And so even if there wasn't consent, the entire environment, and the context allows us to go a little bit further, even if we do not get the explicit consent of the individuals concerned. The major problem or the major, issue, however, is if the data is used today, what do we do with the data later on? And do we open up the sky? Do we allow something which we will never be able to undo by now allowing the processing of data for this specific purpose? So, contact tracing by phone or manual contact tracing does raise data protection issues. I think the law does give it protection now because these exemptions are allowed in the current data protection regime, whether here in Jamaica or in Europe. But of course, long term, we have to think about whether we're opening the floodgates. That's the term I think I was trying to find earlier. Whether our use now in 2020 into 2021 is opening up the floodgates for really the surveillance state. And it's a tricky balance to keep or balance to strike, but it's something that we as data practitioners or data protection practitioners have to keep in mind, because we don't want to, give 1 inch and a whole mile is taken. And I think that's the concern that we really have.
Absolutely. Absolutely. And just going back to some of what you said, because although I recognize that the debate about data protection laws and public health is something that it's being debated continually and consistently, especially probably in countries like Europe, where data protection laws have probably been quite stringent, and now you have this massive health challenge, and one has to find the balance between probably how the extent to which privacy can be protected versus the public good, citizens and society health in general. But I wondered whether or not there may be degrees, because it may not be prudent to just sort of, for all intents and purposes, sort of open the floodgates to say that because we are dealing with a global pandemic, that all matters related to data protection are kind of off the table. But could there be some basic minimums that we probably could maintain? What are your thoughts?
Agreed. There could be some basic minimums because the safeguards, especially the constitutional safeguards in respect of informational privacy, those safeguards exist. Whether in Europe, and for us here in Jamaica, coming out of the NIDS case, that's something that we know that we don't have. We now have informational privacy. And certainly, if those data privacy boundaries are overstepped by the government or even by a private entity too, there is redress that can be sought, on the basis of there being a breach of the individual's right to informational privacy. So it's a very hard road to trod, and I can understand any government, moving ahead. It's funny that for us in Jamaica here, because we did not have a Data Protection Act, the allowance for tracking via the cell phones and the requirement that people download this application was actually in an order that comes under the Disaster Risk Management Act. And so, it's one of those emergency orders that we have here in Jamaica. And it's I wouldn't say it's a doomsday sort of legislation, but it's something which it really shows how seriously your rights and how quickly your rights can be taken away in the context of an emergency.
Understood. Yes, that's quite sobering. Just give us a little bit more insight into what information privacy entails, please.
So information privacy is a continental European principle, which comes from a belief within continental Europe that the individual personhood is important, physical individual is important, as well as information on that person, because you can recreate the characteristics of that physical person, or the physical characteristics. And so whether it is your name, date of birth, geographical location, sex, workplace, anything which is personal to you, including nowadays your IP address or photographs, that those things should be kept in a manner which really shows that there is some respect for the individuals and for individuality. And that has spawned, of course, data protection laws within continental Europe. It came across to the UK, and of course, Europe on a whole has led the way worldwide in sort of, letting us borrow that sort of jurisprudential principle in respect of informational privacy.
Okay. All right. And I guess just going back to some of the things that you said, and, in terms of looking at informational privacy, and I think one of the things that I'm concerned about, for example, and I'll talk within the Jamaican context, because, we do contact tracing of, individuals who have come into contact potentially with somebody who may have COVID-19. And I guess they're being contacted manually, as you indicated. And I guess hopefully, there are structures in place to manage their data, their information, because I'm concerned about, and especially, I can probably just say from the Jamaican context, whenever these days you can't even cough in public because, the fares are quite great. So I'm concerned about, the extent to which there might be somebody who is found along, the tree of a contact tracing process. And, it could be revealed who this person is, and yes, they may or may not have it, and especially if they do not have COVID-19, the implications to them in terms of, the society, their workplace, and so on, if that becomes public. And I therefore was wondering the extent to which we might be able to navigate this situation, this pandemic, with anonymization up to a point, of course. I'm just wondering, and looking at informational privacy and the fact that contact tracing in Jamaica is a manual process, how do you think anonymization could work, or is it feasible at all?
And, that is a very good question. But you've raised two things, actually. The disclosure of the person's status, whether they have COVID-19 or not. I believe within the health sector, there are classifications regarding certain diseases. Some are more infectious than others. And those which are very infectious, there is a view that the public health authority should be informed. Whether your workplace needs to be informed is another thing. I believe the law also allows for that. Now, there's a point beyond which anonymization just doesn't make sense. You're in a workplace and you tell 10 people around one person, sitting around one person, that this person, you need to isolate, you need to quarantine. The obvious implication there is that the person who is the one variable, the other person who is, standing out, is COVID-19 positive. So it's a very tricky one to do. And I can understand why, albeit there are privacy issues, I can understand why those disclosures would be made, and I believe the law does allow for that sort of disclosure for highly infectious diseases. In fact, our health regulations and health laws do allow for such disclosures as well.
Okay.
So it really is a tricky one. You've mentioned also anonymization. I think when you think of anonymization and pseudonymization, to another term that they use, that's really used for scientific research to a large extent, so that you can put people's names in and they aren't, at a later stage, if someone needs to do the tracing, they aren't located on the basis of their health statistics or on the basis of their sensitive data. But that anonymization is really for research purposes, statistical research purposes to a large extent.
Understood. So as we begin to wind down, just a few more questions, please. And in our one of the previous conversations we have had, you mentioned Jamaica Eye. So if you can briefly remind our listeners what Jamaica Eye is and what were some of the concerns you had with that initiative, and what might be the implications now, looking out with the Data Protection Act coming into force eventually?
Okay, so Jamaica Eye is a program which was touted by the Jamaican government regarding really cameras in public and having a camera bank, having those cameras linked to a central location, a centralized location through which there can be monitoring of people. And several people raised a concern that this is great for crime fighting, and it actually has been implemented. They don't tell us a lot about it because one, they don't want the cameras stolen, and two, it's a national security feature. So we can understand why there wouldn't be a disclosure about the location of the cameras and where the cameras are, where the data is stored, footage is stored, because it's a national security feature, and we can understand the reluctance of government in that regard. But at the same time, that doesn't preclude us from having laws protecting it. And quite frankly, the bigger concern for us then was, with all the data protection laws, what other laws would cover it? And we are, of course, satisfied that our Data Protection Act, when it does come into force, does not exempt public authorities. In fact, public authorities need to have a data protection officer, right? That's the first thing. And two, generally, the Crown can be held responsible for any sort of action against the data subject, against individuals in relation to their information and privacy, in relation to their data, really. So there is provision under the Data Protection Act, which eventually will protect all of us, even in relation to Jamaica Eye. I mean, there are other concerns about Jamaica Eye, in fact, if it's working or if it has gone, far enough, because we really see it as a good crime fighting tools. We just want to make sure that the regulatory framework around it is also sound.
Absolutely. Okay. I am concerned about it as well. As you say, it is a good crime fighting tool, and you just hope, though, that the information or the data that is being collected on people, and a lot of it, I guess, would be video. You're sort of curious as to what use it's being put to, and how it's being stored, and how long the images and so on, the data is being stored for, and so on. But I guess, as you rightfully said, not a lot of information has been placed in the public domain about it. But do you think that there may be, like, whether or not under national security, there might be ways that they can circumvent some of the provisions under the Data Protection Act when it comes into force? I don't know if circumvent is the right word, but...
Right. I think I know where you're getting, where you're going with that. And you are on the right track. There are exemptions to consent, for instance, if it is that there, again, public interest requires the data processing of the individuals without their consent, or whether it is legitimate, given the circumstances. And these two reasons are, especially the legitimate processing, are developed because we recognize that in today's world, we process so much data about people that they never know that this is being processed. And it really is hard to get the consent of individuals at each occasion or on each occasion. It's just not practical for us to use consent as a basis for processing data of other people. And so the law does allow us to use public interest reasons or legitimate processing reasons, legitimate use reasons, in the event that we cannot get consent. The standard is very high, even then. And for sensitive data, for instance, health data, and we go back to COVID-19, when we are using people's health data and their health status, in several occasions you do need consent. But the law does recognize that consent is not always possible, and we need to try to remember that on some occasions.
Oh boy. Yes. That sometimes can be a difficult pill to swallow, because as much as sometimes you may not feel as if you have anything to hide, but the fact that you may be under surveillance even when you are not aware can be quite disturbing. So
Agreed.
And just my final question. So just looking forward, what are some of the trends in privacy worldwide that you're seeing? And perhaps give us some insight into what might be happening in the Caribbean or implications for the Caribbean.
Trends in privacy. Well, I'm going to go back to how I started this podcast about trends in privacy, people working from home, people using corporate data at home, and so opening themselves up and their companies up to significantly more attacks. And the cybersecurity, techs, they will tell you that cyber crime is up, cyber attacks are up. And so you're seeing lots more activity in that field. You're seeing lots more, when you look at Zoom has gone through so many different updates to, for instance, the other day, I wanted to share something from my inbox to share that screen, and Zoom doesn't allow that anymore for privacy reasons, right? So that's one of the updates that Zoom came up with. And so you're seeing a lot more applications being privacy sensitive and privacy by design, which is developing applications with privacy at the very forefront of the developer's mind. That's coming up more and more. And there are certain principles around privacy by design, which, you're seeing people talk about. In addition to that, international data transfers are also becoming quite topical. If you follow data protection, you will know that there are lots of cases and claims, lawsuits really, by activists about the transfer of data between the US and Europe. And so that comes up for discussion quite a bit. I mean, to us here, maybe a figment of the imagination, but we are seeing, lots more cases about data transfers. And I think you're going to see a lot more about that, as well as digital transfers become more topical as people start to trade in data. Data transfers between countries have become much more prevalent than they are now. So I see that as an increasing area for data protection as well.
Wonderful. I guess exciting times ahead, especially with corporate privacy, international data transfer, just cybersecurity challenges as well. So I think, I guess there's still a lot of work, and the area is evolving, and certainly having to grow to meet the challenges that we are experiencing.
Correct.
Grace, this was just such a fabulous conversation. Brief but fabulous. Hopefully we can get you for a longer period another time. And just thank you again for just coming on and just giving us a bit of an update as to what's going on in the world of privacy and data protection.
Anytime. It's an evolving area, so there's lots to discuss.
That's it for today's episode. Thank you so much for listening to the ICT Pulse podcast. You can find links to some of the things we talked about on our website, ict-pulse.com. If you like this episode, please show your support by leaving us a review on iTunes, as it will help others find the show. You can email us at info@ict-pulse.com or drop us a note on our Facebook page, facebook.com/ICTPulse, or via Twitter @ICTPulse. We hope you'll join us again for our next episode. Take care.